how do we avoid appealing if they're suggesting rapid employment instead of education? This is going to come down to argument in the minute. And there, we have resources in the group that help with this. If you can find our videos, we had a bunch of videos in there, like over 50, that were like 50 minutes each. We had more videos than anywhere else online. And apparently Mark Zuckerberg made those disappear. So I'll have to put those back up somewhere else. So they may not be there, but I'm going to do it so that you guys have access to it. Some of them are old archived videos, but the information is still relevant. VRE doesn't change its regulations too often. And I can't think of anything really substantive that's changed. The policies have changed a bit, but good news, your case is going to be governed by the statutes and the regulations, not their policy. Now, they'll try to implement their policy and bend you to their will, and that happens, but that's not how it's supposed to work. So anyway, to this question, rapid access to employment. You have two options, either cooperate or fight, right? If you cooperate, you're going to accept a plan. You're going to be stuck in that plan for however long the VRC decides. And if you're unsuccessful, you may miss out on 12 months, 18 months of training, right? And so what is the cost to you, training? So I know the cost to me as an attorney and as like a doctor or whatever, if I had to delay 18 months, then that would come off the back end of my career, because all of us have a shelf life. We're only going to make it so far as our conditions allow. And there's no way to fix that. We're disabled, right? So we only have a certain runway, and that runway is dictated by God and our willingness to follow God, and that's it, right? And then when your shelf life is up, it's up, and that's just how it goes. So what is the cost of this? So a physician, I guess, would be maybe an example. Look at the tail end of their career and subtract 18 months of earnings off of that. That's the cost, right? Maybe $500,000. So their desire to push and use rapid access to employment, sometimes it's appropriate, and sometimes you need that information, or they do, to support the case. Other times, no, they don't, and they push it anyway when they shouldn't, simply because of a policy or a local policy. So national policy, local policy. This gets into what I talked about before. Some local policies require this even though it's not lawful. Hey, folks, it's not lawful. You got to follow the law. There's a reason they call it law and must follow, right? Follow the law. They don't say follow VRE policy or follow VRE local policy. And in fact, when there's a conflict there, it has to be revised. And a lot of veterans suffer when VRE makes bad decisions based on bad policy, right? Veterans have a right to fair process and due process. A fair process also includes getting informed of your actual rights, and VRE does not do a good job of this, okay? I'm just telling you, it does not do a good job of this. I haven't been asked to provide written testimony to Congress in a while, but I'm going to keep an eye on it now, because somebody's got to tell these guys what's happening in the field that is an attorney, and I'm one of the only ones that does this, and it's, a mess. So anyway, that's my feedback there with rapid access to employment. If that's your only option, it's your only option. If you have to go into the appeals lane, you can't just ask for reconsideration like you used to. They will render a decision, and you are bound by that decision until you either reopen it or provide new evidence, right, under a supplemental claim, or you timely do a higher level review, or you submit a formal appeal. I would not suggest a formal appeal right now because they are taking 4 years to do these formal appeals, and it's obscene how long it's taking the board to get through this. Hopefully it gets fixed. I know our friend Cheryl Mason is now back at VA as a senior advisor. She's awesome, and hopefully she'll get in and they'll fix the board and make it right. But right now the 4-year delay is absurd. It's totally jammed up the system and caused a bunch of backlogs again on veterans claims. And if you don't have a timely adjudication, like in VRE, you're screwed. And it's going to cost you a lot. It's a financial consequence that you can't get that back. You miss 1 year or longer, 4 years, right, for justice. I mean, that's absurd. I can't even believe they get away with it. It should be a crime against humanity or something, or some kind of human rights violation above and beyond what we see within our U.S. legal system. So maybe that's something to look at for you VR&E users who have law degrees, to start looking at the international legal consequences of how VRE or VA treats veterans in the U.S. Maybe outside of the current framework, and you could bring a ICC complaint. So anyway, having said that, other questions. So rapid access to employment. Argument in the minute is the only way to fight this. This is something I do as an attorney for my clients. But argument in the minute is a powerful tool, and written argument to substantiate your position about why you are not qualified for suitable employment could be important. You know, it's hard to say. Each person's case is different. It really depends on the background, whether they're actually qualified for suitable employment or whether there's a disagreement there. You know, there's a lot of different factors. So sometimes you may need to take the rapid access to employment. And if you're unsuccessful after good faith attempts to do it, then you might be able to use that evidence to your advantage.